in no time. That director, if you are here, please, you can request the mic so that we can continue from where you stopped. But if not, we may just have to continue without you. But I know you had added your question considerably to a very large extent. But notwithstanding, since we have like relatively okay, the numbers are increasing. Please let's situate the space. Let's share the space. Let's get enough people in here so that we can have the conversation. I usually before I used to like space that does not have many people. I don't know what's happening nowadays. But anyways, it's because this case we need to get many people informed. We need to um, enlighten a lot of people. That's why it's very important. So please let's share the space. But while we wait for more people to join, I'll just go to Oluwadamilare. Oluwadamilare, please go ahead.
Good afternoon, 1 million match crew. Good afternoon, everybody. I'm Canada, I see you guys. GP, I see you. Still on this PO written address. Can you hear me, please?
Yes, go on. I can hear you.
Yeah, so still on this PO's written address, I had the liberty of just scanning through their final response. But the second and third respondent question, written address, sorry, I had about 2 or 3 issues that were of major concern, which I think the LP addressed, which was, the first one was that the court case, that the evidence that we tendered for the court case was not registered in Nigeria. And the LP address really addressed that particular fear of mine, that we only needed to register the evidence if we wanted to affect the judgment. And I think UC Maxwell explained that in Mindset Speech yesterday, whether and differentiated the difference between enforcing the forfeiture or that the judgment had already been delivered, that we are just enforcing it as regards our constitution. So I really enjoy the part of the LP's response in addressing that question. The second one was when Wole Olayipeku was also attacking our witness in regards to the AWS, that she doesn't have an employment letter at all. That particular concern was really, really addressed by the LP's final response. They even stated that Olayipeku cannot continue to attack our weaknesses without him submitting a counter evidence to counteract his queries. That also really, really got my fears, allayed. The reason why I was really scared is because I know with the forfeiture we can actually nail Tinubu on the grounds of disqualification. And if what the LP lawyers said regarding that we don't need to register the evidence before our lords can actually grant our prayers, then I think that is a very, very big win for us, because that was the only ground Olayipeku had, that we didn't register the evidence, so therefore they should disregard it. I'm really, really happy about that. It was a really, 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 really nice submission. I'm not a lawyer, so I really got lost, and I'm really hoping you guys shed more light on the non-compliance issue. I think they dwelt majorly on the non-compliance issue. But I had just a quick question. It's more of a logical question rather than the legal jargons. The first question is, it wasn't part of our prayers that the votes should be recounted. I don't know whether it was, but can the judges actually decide that these votes should be recounted according to IREV? Secondly, in the legal response, and what Wole Olayipeku was saying was that in regards to the 18,000 blood polling unit results, he said our witness, which was the professor of maths, only tendered for Benue and Rivers State, and I think one other states, and that those 3 states cannot be enough to nullify the election and all. But my question is, if those 3 states were deducted from Tinubu's win and added to PO's win, Is there a way, because in the response, our lawyers only just said that if they can deduct the two states, or it was the two states, that if we can deduct the two states, that it will have a significant effect on the total result of the proposed winner. But my question is, if those two states were added to us, would that make any significant impact on who was declared winner? Thirdly, if we were able to nail Tinubu on the disqualification and render his votes invalid, states that our witness, the mathematician, calculated, will they first of all be deducted from Tinubu's votes and added to PO's votes? And then the other votes he had will now be rendered invalid, or his stolen votes will be rendered invalid, which would automatically affect the total amount of votes that PO has? Or will there be a recount and then the appropriate votes allocated to Tinubu, and then those votes allocated to him will now be rendered invalid? Because in terms of disqualifying him and rendering him invalid, my fear is will the stolen votes, because if he's rendered invalid and the stolen votes are actually also rendered invalid, and there's a recalculation between LP and PDP, I don't know whether that would actually affect the total votes counted. So my major concern is it possible for there to be a recount, sort out the appropriate votes, give Tinubu his votes, then disqualify him and void those votes? I hope I was able to make sense with my question. Thank you.
All right, your questions were quite. I think I got lost at some point, but I want to believe you still followed. But I mean, for me, my opinion is that, and your questions are really, they are really probing. I don't even think you. I mean, we can all postulate. We can try to say, oh, we think, we expect, we think, but nobody really knows. I don't think anybody really knows what. As per recount, I think I don't know whether you meant recount of ballot papers. That's probably totally out of it. There's no way you can recount those ballot papers within the next how many days that we have left, except you want to employ many people, of which the more people you employ, and I'm just trying to take the imagination very far, of which the more people you employ, the more chances of you, become subjecting, how do I put it now, of you being open to some kind of dangers, how do I put it now, of corruption of data or something. So that's really my thought. But as per, I think people should get this. PO's argument on, I mean, the court cannot ignore those arguments. That's not the fact, except on fraud legalities. They cannot ignore those arguments. You can't say, oh, an election was done and it is proven that some votes are not accounted for, and you just say, well, it doesn't matter, go ahead. I mean, you get, so your question will require different scenario analysis, and I don't know if Yusuf Maxwell will be able to do that. Yusuf Maxwell, are you here? Maybe you can just take like a summarize.
Yes, I am.
Okay, go
I
ahead.
am here. Okay, just to add to what you have said already, the thing is, you may not be seeing mathematical computations. I have tried as much as possible to dissuade our minds from that. That is why I've always said I don't know what are other people's views. This is subjective, and this is just simply my own views. From my entire study, I went to court every day and everything. From my entire study, I realized that what you may be looking for as to calculations, you may not see them in our documents because of the angle at which we are coming at the entire case with our petition. I told you categorically that we are questioning majorly the process of the election. And when we talk about the process of the election, that is where it has to do with non-compliance, corrupt practices, and all of that. But when we come back to the numbers, they've tried as much as possible to also incorporate the numbers. That is why you see us questioning 18,088 polling units, which comprises of 2 states or 3 states particularly. Now, your question as to whether it will be added or whatever, remember that these 2 states, all the votes there cannot be given to one person. there were about 5 million accredited voters in those polling units within the state. They cannot pack everything and give to Peter Obi. He's arguing, he has tendered documents, and he has furthered arguments to prove at least these are the ones that we know. And we can say particularly that he has tried to prove that in this state, Rivers, Benue, and the other place, I won. These are the computations. He has given you numbers there. He has referred you to the possibility of uploading a particular document which is considered from EC8A and seeing a blood document on the portal. So if they are not going to go by his computation to give him the winnership or the numbers going by what is on IREV as what he got in that place, then he's also praying that these areas, because of you cannot really ascertain them, that they be cancelled. And we are talking about in this River State, what's his name? APC was given how many votes? I think is it over 1 million? I'm not sure of the numbers right now. They were given a lot of votes. PDP were given a lot of votes, and then Labour Party. So it will all affect each and every one of them. So these are the areas that we've seen particular numbers as against other areas. Of course, we tender reports that also shows some numbers and calculations, in different other polling units, particular polling units in Adamawa, in different places. But then until the entire documents are done with them, you can. And another thing I've always stated is that I was not privileged to see all the documents tendered. So I may not even, the reports that some of these witnesses tendered, I didn't see them firsthand. So I may not even be able to comment as to what are the contents of this report, if these reports are showing the numbers, the true numbers that are derived from, the beavers, or the true numbers derived from the IREV and all of that. So that's my answer to the question. Thank you.
Okay, all right. Thank you very much. You see, I'm trying to pull out. So there's a tweet that Spotlight made. There's a tweet that Spotlight made yesterday about how, AA on Mindset Space with you guys yesterday also said something very similar. It is important, like Yusuf Maxwell said, even in this meeting address, you will hear them make reference to. So apparently, from this meeting address, I got to figure out that part of what's it called now? What the prof tendered is a breakdown of polling units with overvoting. In fact, man, there was one place where that question that they asked the prof about, a polling unit that has 40 voters, 40 this, and the man said there's no overvoting here. PO's lawyers further explain it. The only way you can't decide overvoting from EC8A alone. You have to go and bring the Beavers this thing. So on the real Beavers report, that polling unit had 0 accredited voters. Right? So apparently, in that prof's document, he had analyzed overvoting, which people don't know the implication of overvoting if the court applies it. Many people's votes will cancel. It will affect everybody, but it will cancel many people's votes. So that's like another angle. So we weren't going to see the number crunching on the written address. If not, this written address would have been, I don't know how to put it, but I'm going to read the tweet from Spotlight yesterday. Spotlight said many people have asked why the LP lawyers didn't crunch the figures to show how PO won the election. I came across this response from AA, and I hope it helps. There is something called trap of antithesis. Trap of antithesis. When one arm of your argument has the effect of cancelling the other. That's why earlier I said that even if the court, by the time the court nullifies, how will I put it now? The court disqualifies Tinubu, they cannot actually declare Atiku because Atiku's argument already disqualifies himself. He did not get 25% in FCT. So it's called, according to what he said, said it's called trap of antithesis. When one arm of your argument has the effect of cancelling the other. The LP lawyers avoided that trap. If you say the election was irredeemably flawed, you can't directly say you won. So they avoided the trap. But gave the court a way out, a way around it, because it is the relief claimed by the petitioner that gives the court the jurisdiction on what to do. LP also made alternative prayers that if the court believes the election is not irredeemably flawed, it should compute the result and declare Peter Obi winner. So it's why sometimes when I hype the LP lawyers, I'm not doing it because they are LP lawyers. I'm doing it because some of all these questions we are saying, these people have answered it long before. when they were writing the petition, some of the questions I had in mind, they had answered it even when they were writing the petition. Because if you will go to the petition, the only place they made reference to numbers was on the grounds of non-compliance with the Electoral Act. So if they had gone ahead to say, oh, we are saying the election is flawed, very flawed, but we are also saying we won, you would just say, because by the time the court picks one and say, okay, we agree with you that we are, for us to determine that you won, we will have to determine already that you already agree that you accept the result. Now let's determine you won. And that fight is not a fight that you can guarantee that you will win it. Because some of the things that you calculated and made you win, the court might not regard it. And by then, you have already given them a reason to say the election is not flawed. So it is why it is a very calculated move. It's not, I mean, sometimes what will excite people is, oh, some people just want to see LP lawyers calculated the results and they just show that Peter Obi scored 10 million, Tinubu scored 7 million. And they'll say, yeah, everybody will be happy and they won. And the judgment will shock everybody. When by the time the court is going to say, sorry, you went on with the numbers, we agree with you, which means you already accept that the result was not flawed for you to go further. Now let's go further with you. But this thing that you calculated, we don't agree with it. This one cancel. The 10 million that Peter Obi calculated that people were rejoicing about, all of a sudden may reduce to 6 back. And people now start to say, oh, the court did. So it is a very intelligent, it's why this topic is here, that Peter Obi's legal team, they be good. Sorry, not the literal good. The greatest of all time good. All right.
We will use an holistic approach to interpret goat in this sense, not the literal interpretation of goat.
Your head is there. Wisdom, please go ahead.
Good afternoon, everybody. UC Maxwell, special afternoon to you. In fact, the way you analyze all these things, you just make it easier for those of us who are not actually a lawyer to understand what is actually going on in total. Thank you very much. I especially thank you for your analysis and your time and everything. May God continue to bless you and reward you in Jesus' name. UC Maxwell, you are not left out. May God continue to enlarge your coast in Jesus' name. Amen. I actually gone through the written address yesterday, although I was unable to finish it, but the place I just gone through, the question I was actually asking myself, where did Peter Obi get all these lawyers that is actually representing him? I think there are about 20-something in numbers. Then I was not asking myself, when the court declared Peter Obi the winner, you just imagine the kind of minister team to make Nigeria a better place. Have you ever had that kind of thought in your mind? Even last year, when we were clamoring for, when you wanted to pick Kwankwaso, some of us were actually happy just because we want to get the Kano votes, to be precise. But God worked in a mysterious ways to perform his wonder. We never knew what is actually coming on our way, which is Baba that he made is 1,000 times better than what we were thinking Kwankwaso is. But along the line, just because of ego, he declined. He was thinking of age. He's senior Peter Obi. He will rule first before Peter Obi take over. All those kind of things. We never knew that God actually used it to even take him out of the way by bringing a better person for us. In all of this, I don't actually have more to say. But what I just want to say is that I'm already buying my drink down. I think the judgment day is August 11. I'm stocking my house so that celebration, I will start it from 6 a.m. till 6 p.m. that day for the victory, because I don't, even though all these judges, no matter what the angle they want to come from, whether technicality or fraudicality, so they are not going to escape this one, because we just set trap in every angle. If you face this side, we catch you. If you face this other side, we catch you. In any angle you want to go to, we are going to hold you ransom. No escape proof this time around. Tinubu survived in 1999 because Lagos is just one state, and most of the State House of Assembly members, he pocket everybody. So he was the one that appointed the state judge. So all those things, he was able to survive it. But this time around, Lagos is not just, it's not, Lagos is not, Lagos alone cannot actually give him what he's actually looking for. Just like we always say, Edo not be Lagos, so Nigeria not be Lagos. Thank you.
All right. Thank you very much, Wisdom. Thank you very much. Thanks for the prayers. And, you actually said something that triggered something in my brain. When you when you talked about Dati Baba Ahmed and Kwankwaso, I mean, I've thought about it, but I think when you were talking about it, it made me think about it in a different way. Do you know that apparently if Kwankwaso was Peter Obi's running mate, by now we would have had a Lamidi Apapa as a deputy as a vice president, most likely. Because, I mean, even in NNPP, he has already gone to shake hands, maybe make some kind of deals with Tinubu and all that. So what we would have had is the vice presidential candidate already saying things like, let's move on, let's accept it, it is the will of God, let's not. That was like a big trap that, I mean, God, and it's those kind of things I think about, and I just, talk about the divinity part of this movement. That people, understand that pastors make the attitude of some pastors make some people, kind of question that, I beg, these Christian people in a scam. But I mean, personally, I've seen a lot of things in the movement to believe in the divine part of it. Anyways, so we'll just look at some of the things, because this space was really for the written address. So I just want to first point out some key points. When I read, I highlighted some key points in the written address. After which I'll go to myself and Mr. Maxwell. We can go to the objections that LP made and their reply to. Thank God that Adegosaki is here. Adegosaki now go. I thank God that I tell him to go read the document by himself. Anyway, so I'll just point out some things that were catching for me. Right, I highlighted them so it will be quite fast. And this is from the written address in itself, not the objection. So one thing that Peter Obi's team kept doing that I liked was the use of the word unchallenged. Unchallenged. Because apparently, I think it was Justice Samani or another judge in the appeal court, and it has been established in law that by the time a petitioner, the first burden of proof is on the petitioner. When the petitioner, brings all the proof that he can bring in, it is now the burden of proof shifts to the respondent. So the respondent is supposed to now bring his own proof to counter the petitioner. So it's like a scale of balance. So if the respondent's proof is much, it will outweigh that of the petitioner. So apparently, APC did not bring any proof except to just bring Bamidele to come and. It is why that rumor of APC looking for a rerun where they are not disqualified is founded. That rumor is founded. Because you can tell that they didn't bother to try to argue any other thing. They instead argue just qualification because they know that the only thing that they need to protect is Tinubu not being disqualified. It is why I tell people that, you emphasizing rerun sometimes might be shortchanging. Because APC themselves are not really arguing against non-compliance as much as they are arguing against being disqualified. If you notice, their only witness came to talk about being disqualified. He didn't really talk about non-compliance. He agreed he has not visited the IRF and all that. So Peter Obi's lawyers kept using the word unchallenged, which simply means we brought this, the respondent is not challenging, and that was quite, that for me was quite catching. Then there was another thing they pointed out, which was the powers of the manual for election officers. I haven't thought that where the powers of the documents that INEC has ends is at the regulation and guideline. But in this petition, in this document, Peter Obi's lawyer proved that the powers even extend. The power extends beyond the regulations and guidelines and extends even to the manual that is used to train electoral officers. And that was backed up by law where, the court had said before that the manual of election, issued by INEC are not mere instructions or directions. Rather, they are subsidiary legislations that have the force of law, which means the manual that INEC used to train all those presiding officers is law in itself, according to the court. And when I read this, I was like, oh no. If to say Peter Obi's legal team just give me INEC manual alone, just scatter this INEC manual for us. I swear. In fact, from INEC manual, I would have been able to prove that INEC did not only not comply with not transmitting results, they also did not comply with synchronizing of BVAS data. As in, that would have been like epic, to be honest. But I mean, that was not really needed, to be honest. So it was also quite. And from that guideline, you discover that what the Constitution said is that on completion of all the polling unit voting, and I'm reading from the documents now, voting and results. This is from INEC guideline. The presiding officer shall. So it's not as if may or can or should, or it shall. Like it's really compulsory if you follow what lawyers say. So, and they went further, and I'm reading relating to non-substantial compliance, because yesterday we dealt with forfeiture, we dealt with double nomination. Earlier in this space, we dealt quite a lot with 25%. So I just want us to touch the last part that we've not dealt with. I mean, we won't dealt with it. People have asked questions relating to it, but I just want to point out some things before maybe more people come and make reference to it later. Another thing was they said somewhere in page 16 said one of the problems noticed in the electoral process. So listen to what INEC said, right? Let me read what INEC said. Indeed, my noble, this is in paragraph 4.41. I don't know, but it's in page 16. It said, indeed, my noble lord, in paragraph 2.9.0 at page 36 of the manual for election officials, which by extension is now a law, the first respondent, which is INEC, under the subheading electronic transmission / upload of election result and publishing to INEC, capture fundamental importance. So INEC in their manual, in their training manual, which is now a law, INEC captured fundamental importance of the requirement of electronic transmission of results as follows. So listen to what INEC said as why electronic transmission is important. Just listen. This will be a very good ground for the court to determine what non-substantial compliance is. All right, INEC said this. One of the problems, this is INEC, I'm quoting INEC. One of the problems noticed in the electoral process is the irregularities that take place between the polling unit after the announcement of results and the point of result collation. Sometimes results are hijacked, exchanged, or even destroyed at the polling unit or on the way to the collation center. It becomes necessary to apply technology to transmit data from the polling unit such that the results are collated up to the point of result collation, declaration. The real-time publishing, again, this is their manual. The real-time publishing of polling unit result on IREF portal and transmission of results using the BVAS demonstrates INEC's commitment to transparency in result management. Remember, I said this last time that the Constitution part that said substantial compliance said with a principle. He said the commitment is backed by section 47, 60, blah, blah, blah of Electoral Act, which confers INEC with the power to transmit election results electronically. The system minimizes human error and delays in result collation and improves the accuracy, transparency, and credibility of the result collation process. All these things I just read, it was INEC that said it in their training manual, which the court at some point had upheld that training manual is, I go back to what the court said. The court said the training manual is not mere instruction or direction. Rather, it is a subsidiary legislation which have the force of law. So everything I just read now is in a document that has the force of law. So then another thing that they pointed out that was quite catching to me is the fact that, and this is on page 17, They mentioned so some people don't understand that it's not only that INEC did not transmit electronically. INEC did not transmit at all. LP pointed out that INEC made provision for offline upload of result. Offline, they made provision for it. But they did not do that because what the INEC have said failed on election day is the in-transmission app. So the in-transmission app failed to not only transmit online, it failed to also transmit offline. So LP pointed it out. So that's a proof that, I mean, even if you want to say, if you notice, APC at some point tried to argue that the cause may have been network. LP killed the argument by saying, even if you want to say it's network, there was provision for offline upload, but that was not done. So people should understand how deep LP lawyers went in this. I want people to know why this topic is GOAT, is greatest of all time. I didn't manufacture it myself. Of course, they made reference to, so okay, yeah, this is why I marked this piece. I just remember that our, favorite Oyetola's case versus Adeleke that I always read. If you notice, if you've been on this space a couple of times, I've been reading this thing before this came out. When I was reading, I was like, most of people not go think, say, I did the legal team, I beg, I not did. What was there? It was simple. The regulation provided that the beavers will be used to scan and complete. I don't want to read it. I think I've read that a couple of times. And this cancels whatever they were. Whatever. If I go to the objection, we'll see something there. I don't want to preempt it. As the name depicts, the collation system and the INEC result view portal are part of the election process. That was on the Oyetola and Adeleke judgment. So I think those are the... Okay. Another thing that I marked here was that, they tried to play down the witnessing of the AWS staff. So these lawyers, when I read this, I was on the phone with somebody and I told the person that, Mom, Peter Obi's lawyers, as in they went all out to protect that AWS staff. Because the way they did it was, they actually said that, apart from, the annex of a profile, resume. Okay, let me put it like this. Let me just read it. This is in page 21. They said, with due respect, I was going to say some violence today that if you read this petition, usually when lawyers write, they write on behalf of who they are representing. Do you know, if you read this document, if you read Tinubu's document, you know that Wale Onanuga sounded like he was representing Tinubu, very insulting, very condescending, very annoying, disgusting, and everything. If you read Peter Obi's own, you will almost discover that it reflects Peter Obi's document. Maybe on violence minute, I'll dive into this. But if you notice, one thing they kept using, go and find, if you search respect in this document, you see it in many places. When I read that, I was like, it was almost like when Peter Obi wants to say something annoying to somebody. Like, not really annoying, like when he wants to treat someone's mess up, he will first say, he's my well-respected elder brother. So the lawyers too also put it in this document. So they will say things like, with due respect, the second and third respondents seem to not be aware of the prevailing technology with respect to employment documents in advanced corporations such as AWS. So they were trying to, talk about, they trying to play down AWS and all that. So at some point, in fact, they said so many things. There's one point I wanted to point out. So they went for that to say, it is important that the PW7's confirmation of employment, apart from indicating that it was issued by the Employment Resource Center, Amazon.com, Incorporated, also contains a further statement. And this it contains, they said, if you have any question, please contact us at that. So they were saying that the letter had a phone number. My lord, neither the second or third respondent, nor anyone whatsoever, including their sole witnesses, made any effort to contact Amazon Resource Center at the given number. Yet, it is being falsely argued that the PW7 unchallenged proof of our employment as a staff of Amazon is manufactured by us. So they were saying there's a phone number there. You did not call to confirm. Go and call. Go and verify. Anyway, another thing they pointed out was so I think they also pointed out that if you follow what a cloud trade should look like, what INEC tendered is not a cloud trade, but I wouldn't want to delve into that court is entitled to draw inference. Yeah, you see, Maxwell have said it so many times on this space. So Justice Samani has said in a judgment before that it is equally true, and I'm reading what Justice Samani said, that in the resolution of issues before it, the court is entitled to draw inference from proven fact in order to reach a decision on an issue. In other words, a court or judge can draw inference from oral or documentary evidence tendered before it. And Justice Maxwell said that since they did not tender anything to counter it, the judges can say, okay, we can assume that from this we can infer. That's what this space was saying, and that was said by Justice Samani himself. I just cited another place where I said, they said, my well-respected elder brother, but this place again, they said, respectfully, my noble lords, and this is in page 24, the above submission by the second and third respondents further evinces the unfortunate misunderstanding and misapprehension of the real purport of the evidence of PWE4. As in, after saying respectfully, they now say this person does not understand. He has problem with understanding, and so on and so forth, from reports of PWE4. All right, I already said it just now that if you look at the BVAS, the accreditation in that polling unit, where they say there was no overvoting because the man said 40 and 40, that polling unit had zero accreditation on the BVAS. And that was important for them to point out. I'm just trying to see the different points. Okay, so at some point they considered to the fact that, okay, the election may not be liable to being invalidated by reason of non-compliance if the court determines that compliance is not sufficient. This compliance is sufficient, right, or is substantial. Now, they now went to a Supreme Court judgment where a particular justice, to a Supreme Court judgment where the judgment held that one of the judges said that I must point out. Oh, so this was made by this statement was said by Ruth Vival, JSC, Justice of the Supreme Court. So, of course, when I say Ruth Vival, you know who Ruth Vival is, right? So, you know who he is. Not J.R. Ruby's father directly, but if you know the Ruth Vival family, you know their father, they are the person that was the Justice of the Supreme Court. So, this is what he said concerning what substantial means. He said, I must point out that once again, the standard of proof required from not even substantial. See what he said. I must point out that once again, the standard of proof required from a petitioner. Required when a petitioner brings a petition on the ground that there was non-compliance with provisions of the Electoral Act in the conduct of election. I skipped some things because it's not relevant, because that was in 2010, but it's also applied in 2022. In the conduct of the election, by virtue of Section 137 and of the Electoral Act as of 2010, which is also applying now to an extent, the standard is preponderance of evidence. That is to say, one side position overweighs the other. So basically, the petitioner is to prove that there was non-compliance with the provision of the Electoral Act. He then has an added burden to prove that the non-compliance with that provision of the Electoral Act was substantial, that it affected the result of the election. So for people that have been saying why Peter B talked about the 5 million, 3 million, 23 million, how it affects. So the only thing that they needed to prove was that there was non-substantial compliance. After they proved that, the next thing that they need to prove, that's why he said he has an added body. They have an added body to prove that that compliance had an effect in the election, which Peter B approved. Look at where they continue. He said after they proved that it affected the result of the election, it is then the body shifts to the respondent to rebut that fact. Evidence led by the petitioners overweighs evidence led by a petitioner overweighs that of the respondent when the petitioner is able to establish substantial non-compliance and there is only a feeble response. This is quoted, and there's only a feeble response or nothing much forthcoming from the respondent in rebuttal. So they went on to say, in the instant case, the petitioners have provided substantial evidence establishing their case of non-compliance, while the respondent provided no evidence whatsoever on this point. They woefully failed to rebut the petitioner's strong claim of non-compliance. So that's why I said APC, none of the respondents proved whatsoever, brought any proof to come against this one. And this is something that was said by the Supreme Court. I think I will stop there, because if I go further, you people may goat this document more than myself. You may goat it. Anyway, let's just quickly take a couple of speakers before we come to the objections. Office of the City, please, if you want to speak, ensure your hand is up. Office of the Citizen, please go ahead.
Okay, hi. We're Nigerian. I don't know I don't know who has more energy between you and Peter Obi at this rate. Thank you very much, guys, for this. It's beautiful to come and always have company. Let me use that word. Fellow obedient. There's always a place that you can hang out, right, and discuss these things. I have gone through a significant portion of the written address, and it's truly a beautiful document. Thank you for even breaking it down some more. UC Maxwell will give us these things from a legal point of view, explaining it very simple. Then you will explain it some more as a non-lawyer, even trying to help the rest of us even understand it more. Thank you so much for everything that you do for us. And really, that part about the unchallenged is what, for me, is like the most beautiful part of it. I see people peddling different APCs, different kind of nonsense that Obi is not asking for to be declared winner. And I just laugh. These guys don't read. I realize that there's really no need to engage people that don't read. If you don't read and you come and talk, then what exactly is the basis of your argument? And I'm glad that us obedience, we take out our time to read this stuff. In fact, we are not even depending on what others read. We are reading these things for ourselves, right? We are disappointing those people that say that if you want a black man to not know something, put it in a book. We are those that have disgraced that axiom. All right. So thank you very much, guys, in the 1 million match crew camp. Thank you very much, everyone that we are obedient. And I am glad. I am very glad. In fact, the part I want to probably pose as a question in some way. There is 4.67 of the address that says that, let me just read that part, that says that though the court is not bound to accept an expert report, the legal position is also that, quote, they would appear not to have any choice than to do so as long as the expert evidence is unchallenged and uncontradicted, as has been the situation in this case. That's UBA PLC versus Unisales International Nigeria Limited. So I want to confirm that this means that as long as professor's evidence is admitted in court, that means whatever he puts in that report will be accepted by the court. That's exactly what I want to confirm, as in every single word. I'm sure it's much better. Can probably help me with that. Thank you. I have one more thing. Okay, let me just add one more thing quickly before
you add it, which particular place are you referring to? I didn't really get where you are referring to.
4.
Can you the page?
Okay, I did a screenshot. Just a second. Let me look. It's 4.67, page 24. I believe that number is 4.67. It's the first number is blurry. 4.67. So.
Okay, I think I know. Yeah, I think I know. I can see that.
Okay.
Have you seen it? It's actually 4.67. Yeah.
Yes.
It's in page 24. I don't know if it's 4.67, but you see 0.67, Sha.
Yes, exactly. I just presume that it's 4. Look like 4. But let me just restate my question again. So the quote, what is quoted here is that as long as expert evidence is unchallenged and uncontradicted. So in this case, I believe that this means that if the respondents fail to challenge, good. If they fail to challenge and is admitted, then the document that was presented by Professor Wadegu will have to be listened to. I believe that's what this means, right? You have to be accepted by the court and whatever he's presenting as evidence. I believe that's the case, right?
Yes, I argued this. That was yesterday. I argued this. I also stated it again when I was in mindset space. You see, that's one of the things with, you know, bothering yourself about challenging somebody's credibility. You spend so much time challenging a witness's credibility, and you even forget to map out time or space to argue what that witness has brought. Because if you challenge a person's credibility and fail to answer the evidence that the person has brought to court, it is a very, very fatal thing to do. If the court later rules that the witness is credible to testify, it means that you have rid yourself away of the chance to actually question what the evidence that the person brought to court. And that is what they are saying here. When these witnesses came, they were, when you look at their documents, they were bothered that the employment letter, there's nobody's name there, there's nobody's this, that. This particular witness, he was told to conduct this report, he's a member of the party, he cannot do this. You keep on questioning credibility. This same argument is in the PDP's petition. Go and read it. This same argument, where you have uncontroverted evidence or unchallenged evidence. People come before the court to tender evidence, you don't controvert it. It means you have accepted it. Anything you don't create a defense against, you don't argue against, by the interpretation of the court, the duty of the court is to interpret it as you accept it. If during these proceedings, at the time of final written address, if INEC does not submit any final written address, it is deemed that they do not challenge any case of the petitioners or any other person in the case. That is the principle of law. So if indeed this evidence is tendered, they did not further any arguments against it, they did not tender any documents against it. And indeed, if you remember when I went to court that day and I came in, I said it categorically that we have shown documents proving that there are no glitch, there is no this, there is no that. INEC, the burden has shifted to INEC or the other respondents to provide documents. If you say there were 16 million attempts on your server, provide the documents. You don't just say it to the court. Provide documents to prove it. Bring witnesses to come and tell us. So, but, they went into the business of only, firing at the credibility and all of that. So it means that if the court does not hold anything against them as to credibility, the other documents that are tendered in court will stand. That is just simply what it means.
All right, thank you very much, Yusuf Maxwell. I think I heard you say that on a mindset space yesterday, and it was another new point that I was able to get, and that made sense when I added to the question that Office of the Nigerian Citizen just asked. It actually makes sense because I don't understand why they didn't. So it means
sorry, well-meaning, particularly, when you look at paragraph 5.73 of the PDP's case, this is not the only place that they stated it. There are other places they stated it. When you look at paragraph 5.73, they said, also, a fundamental part of petitioner's witness 27 evidence before the court is that the second respondent submitted forged certificate to INEC and therefore robs him of qualification to contest for the office of President of the Federal Republic of Nigeria. This piece of evidence remains unchallenged before this honorable court. The second respondent's counsel deliberately avoided raising that issue and has also avoided commenting on same.
Wait, you see which document are you reading?
I'm reading the PDP's document.
PDP, yes, go ahead.
The second respondent's counsel deliberately avoided raising that issue during cross-examination and has also avoided commenting on same in his written address. This honorable court is respectfully urged to rely on this piece of uncontroverted evidence and act upon same. It is only telling the court, because nobody challenged this evidence, you must just apply it. Anything you do not disprove in court, the court is obligated to agree with that position, as far as it does not lead to the interpretation of a particular, provision of the law. Because as for interpretation of the law, the court will still need to probe the law. But when we are talking about facts which are deposited before the court, You need to controvert evidences if you are challenging it. If you are not challenging it, it's just like objections. If you don't raise an objection when a document is being tendered, you cannot later come to argue it because it is deemed that you accepted the document when it was tendered. So that's the correct position of the law, and it was rightly argued. When you read other parts of the documents of the PDP, other parts of the documents of the Labour Party, you still see these same things. There are other documents that they did not controvert. And you also, anyway, proceed, well.
Okay, Omo, see, when you were talking, my hand just entered my head. I just point for head, as in, hey God, how this court not going to take this qualifying, but I don't understand.
What they argued, sorry, sir, they come here. Let me tell you.
Okay, come
what they focused on doing was, although, like I said, in the PDP's case, it was a founded argument. I told you that. Well, I think I said that here, and I also said it on other spaces, that these are one of the arguments that are found as a founded argument, where they question the timing at which the issue of forgery came into the case. Was it okay? No, not forgery. It was the passport case, that they did not specifically plead it and the rest. But I still told you that it was subject to the argument, the response that I will get from the PDP's case. You remember I also said that because we don't look at arguments from one lens. We need to consider the response. If the response is also solid, then we may be just left at the middle to wait for the court to give its views on it. What they were based on doing was just saying that this issue of forgery like this, he wasn't specific when he brought the petition before this honorable court. He only said that he will argue he wasn't specific. These documents he brought, nobody signed the documents and all of that. Fine, you can argue this. Nobody says you should not argue. But when you don't controvert the document, when you don't negate the document, did they prove that the document was fake? No. Did they prove that the document? And one thing with the principle of law is that if a document is obtained by any fraudulent way, listen to me, please, and don't misquote me. I will give you an example. If a document is obtained in a fraudulent way, it will not stop the court from accepting the document. It will not stop the court from accepting the document. The document will accept it, the court will accept it, use it in the case, but it can later, if we want to institute a criminal action against the person. So now let me give you an example so that you understand the context before you take it out of here. Now, if I have a case with my landlord and there's a document that is in the possession of my landlord, he doesn't want to bring it to the court. If I break into my landlord's house, carry that document and tender it before the court, if the document is admissible, the court will admit it and use it to judge the case. If it is in my favor, it will judge. Later, you can now go and bring an action for breaking and entering in a different criminal suit. But the thing is that I have obtained evidence and I have used it for my case. I don't know if you are really getting the point I'm making here. So
this one
there are several there are several principles of law that are very technical. As a lawyer, sometimes I'm being careful of saying these things because I am not questioning the intelligence of these people. They've gone far in this profession than I have. Somebody like Wale Oladipo is over 40 years at the bar. I've not even entered any year at all at the bar. But the point I'm trying to make is that when you are a lawyer, you need to leverage every option. It is not that Peter Obi doesn't want a rerun. He wants to be declared the winner of the election. But the question is, what if the court does not declare you? That's the question. So that is why when you see in their prayer, after saying, my Lord, rule that I won the election, they now said, in the alternative, in case you did not see it that way, cancel the election, order a fresh one, and disqualify this guy. So there are angles to come at your argument. So if you are going to question the credibility of a witness, fine, question it. But the documentary evidences, the oral evidences that the witness deposits in court, you need to argue it. It is a necessity for you to further prove your case. There are several cases for which parties refuse to argue, and it would always speak against you. I would hold here since I've been talking for too much.
All right. Thank you very much, UC Maxwell. Thank you very much. Almost. That is different. Anyway, because we need to end the space in the next 1 hour, and I want us to go through the objections before we end the space. Because I know that's one part that a lot of people haven't read much. But okay, Office of the Citizen, I'm sure you quickly want to say something, so please go ahead if you can make it in 1 minute.
Yes, in 1 minute. I remember I was saying something about the second part. Another thing that is quite interesting that kind of stood out to, I'm sure it was probably even already mentioned, was the CloudTrail log thing. I'm an AWS guy. I'm hoping that someone will make available the CloudTrail log that was provided so that I can look at it, because I see from the written address that the CloudTrail log that was provided did not even have the things that should make it a CloudTrail log, like they said, event time, event source, event name, region. I wish I could see that CloudTrail log so I can laugh because I've seen CloudTrail logs. Anyway, that's just that's on a side note. Thank you very much, guys.
Yeah. Even when I saw that place, I was like, now why Sosani Kweto asked that question that time? We asked and say,
exactly. You know what I mean? I was waiting for you to just finish this. You are saying I come. See, I said this thing when we left court that day. See, make una try to follow these things gradually. A lot of people, when we leave court, they will come, they will criticize, they will shout, this one, that one. A lawyer may ask you a question that he already knows the answer. It's not because of he doesn't know the answer, but he wants it to be on a record that you have answered it. You understand me? If the witness did not say it that day and you only argued it, the argument will not be solid enough. But he asked the witness, you know something about AWS. You tendered a CloudTrail log to this honorable court. A CloudTrail log is supposed to contain so, and so. Do you agree or do you not agree? He was trying to rigmarole. They continued asking him that question.
His response was, it is there.
Yes, he was first rigmaroling. You know, the way I report my own, I may not tell you how many times they asked the witness the question before he finally succumbed and answered. He kept on rigmaroling and all until he finally answered. And obviously, these are very solid arguments that were used in our case, because if we tender the CloudTrail log and it contains these features, and our opposition, Tinubu, has agreed that a CloudTrail log also contains things, why don't CloudTrail log not have it? So these are the important questions that we need to ask. Thank you, my brother.
All right. Quickly, let's just go through. So, maybe I'll read some of the objections, and at some point, depending on what you have, I don't know if you have your laptop and you're following, or like if you're following, maybe even on your phone, though. I want to first go through the objections, or let me see. The objections by LP's team. That's the document that we objected to. So, the beginning of the document, they stated it very clearly. They said, let me see. There's a place where I want to start from. Please just give me a moment. Okay. All right. So at the hearing of the fifth tendered, all right, they just talked about the witness tender. I don't want to read everything, so I want people to, so we don't end up. So we urge the court to expunge the following documents tendered. The documents were listed, and okay. So the objections that they raised. So the first objection was to the admissibility of Exhibit ROA, whatever. I'll just say. So they objected to the letter being letter from Nigerian police to the United States Consul General, Governor Bola Tinubu criminal record.
I'm sorry, 1 minute. Sorry, 1 minute. Before you proceed, please let me just tell you. Please, this document that 1 minute is reading from is already on the Google Drive. You can go there and look for it and also pull it up. I have been reading it since this space started, even though I've been a bit slow about reading it. I've gone half of it. It's just 11 pages, not a bulky document. I mean, like page 6 of that document. We will see very, very wonderful objections that were raised. He went to Mog. you see different arguments that were raised there, and very intelligently that were objected to. And of course, I've seen the arguments that you said I also talked about. But then, please go to that drive, download it, then you can review it as we read along. Thank you.
All right. Yeah, I was hoping people have it already. Maybe they haven't. Please, if you don't have it, you can download. It's on UC Maxwell's Drive. Just give me a moment. Let me put that on the Jumbotron, so it can be easier for people to get it. I mean, when you go to the drive, I think there's a folder called something. I forgot the name of that folder. Written addresses or something like that. When you click that folder, you see some of these replies. If you have been following it, you easily identify. But why I want to read this because so we can just go through it more like together. So the first thing that they objected to is the letter from the Nigerian police to the United States Consul, which is written with the subject Governor Bola Tinubu criminal record dated 3rd, and the response from the American Consul dated 4th, 1 day later. All right. So this is the objection. They said the documents are not relevant. So they are not relevant to the issue of the second respondent's forfeiture of $460,000 being proceeds from narcotics, trafficking, and money laundering. This exhibit were tendered to deceive. I like this place. These were tendered to deceive and unduik Nigerians and indeed the Honorable Court. The witness admitted that the order of Illinois is not money judgment. The inquiry of the exhibit is a general inquiry for criminal liability and not whether there was an order of forfeiture against the second and third respondent. Accordingly, we order the court expunge this exhibit as unrelated because it's not really related. Then they went on and said, furthermore, the petitioner observed that these documents are not relevant and did not exculpate. When I leave me, lawyers, when I leave me, I did not exculpate the second respondent from the indictment against him. I don't know what they were doing, trying to prove that. Okay, they wanted to prove that it's not criminal proceeding, which helping lawyers agreed to. The petitioners contend that the appropriate authority to provide information regarding the indictment of the second respondent for narcotics trafficking and order for forfeiture is the Chicago court that made the order, and not the general and not the consular general, whose functions are purely diplomatic. You see, and not having powers to certify and confirm the consequences of the said indictment. You go meet consular general for something we court for America do. The confirmation can also be made by the Department of Public Safety or police department in the district where the case was tried. So they're literally saying if they wanted to really get that information, look at where they would have gone to. The petitioners contend the admissibility of the document on the ground of improper custody. So they contended both the use master don't teach us that one. Two things: relevance and admissibility. So they contended the relevance, now they contended the admissibility. A document which is not in proper custody or produced from an improper custody should suffer the fatal fate of not being admissible. This court, in interpreting the relevant provision of the Evidence Act, narrated that what improper custody means. The provision of Section 124 of the Evidence Act is clear. It means documents are said to be in proper custody within the meaning of Section 116 to Section 100, blah, 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 if they are in place in which and under the care of the person with whom they would naturally be. So, others are the legal this thing. Maybe you should also explain that. The import of the above is that a document not produced, okay, they explain it anyway. A document not produced from a proper custody cannot be admitted. We submit that the evidence not having emanated from proper custody, it is inadmissible and should be expunged from evidence. Though emanating from evidence ROA 8, so one of the evidence and the second one, evidence ROA 8, though emanating from proper custody, is irrelevant to this proceeding and it has no basis, and as such, is inadmissible and should be expunged. So that's the objection to the police letter. All right, objection to the admissibility of 12 documents tendered with receipt relating to educational record. I think this was the funny one for me. We said this on the space that day when we were following court. I think it was Arigosaki that asked this question. Yeah, Arigosaki was the one that asked the question. As per why are they
Well
tendering?
meaning. I
Yeah.
feel like what we should do is, do we treat them one after the other? Each of the arguments that have
So
been
it's because of
presented.
time. Okay.
Okay, just
Okay,
proceed
go
then.
through this one and then I'll
Proceed.
read the next one. No, don't worry. Go through this one and read the next one.
Okay.
The first one is the police. Yeah, it's not much anyway. So go ahead.
Yeah, so if you could recall, during the entire case before the court, they tendered some documents and they told the court that those documents, that if they submitted a letter in 2000 and was it 2003, by the IGP of police, for which they requested the letter. And recall also that as for the PDP's case, they tried to advance the fact that that letter was not brought before the court, meaning that the first letter, I've not gone through PDP's objection, I don't know if they later argued it in their own, that the first letter that IGP, what's the name of that man, that fraudulent IGP that time during TAFA, that the first letter that was written was not presented before the court. That the only letter presented before the court was the one that the consular returned, clearing Tinubu of all criminal charges and all of that. So they are stating very clearly that the only person, that the custody for which for anybody to tender a document, that it's supposed to emanate from a proper custody. Now they refer the court to the case of Lawal versus Honorable Commissioner for Lands and Survey of Oyo State. In that case, they stated clearly that documents are said to be in proper custody if they are in a place in which and under the care of the person with whom they would naturally be. So they are arguing that these particular documents were not in the proper custody of the person who could have brought it before the Honorable Court, and therefore should be discarded. Now, the entire issue of forfeiture and all of that, getting the document from the Consular General, they stated and they argued that the only person with the right authority to have described whether Tinubu has any criminal case or a forfeiture case in the court in the US would have been the Chicago court, which issued the judgment, and not a consular, which does not have anything to do with the business of the court. So this is their argument about the documents which they tender. Remember that objections to documents is simply objecting to the admissibility of the documents, so that the court will not admit it into evidence. I will not use it for any purpose to advance the case of the person who tendered it. So that's just it. So that's why I said we can just elaborate on it and move forward. The arguments are not so much. That's how they are. Objections, they are not usually so much. So we can move to the next one at this point. Then maybe after everything, we can now take questions.
Yeah, I think most of the rest are even kind of self-explanatory to an extent. The second thing that they objected to was the document that we tendered relating to education records of the second respondent. I think this master already talked it before as far in PDP's case. It's in another light, but here they said, the LP lawyer said, it is evident that the second and third respondent are mixing up proceedings before this honorable court, as nothing in the pleading before this court as it relates to the instant petition suggests that the academic record of second respondent is an issue before this court. So I like that point. You understand? Olawaski raised it that Olawaski, I think it's Aligusaki rather, raised that why are they tendering results when it's not in our case? So the lawyer has already said that. They went further to say the academic record of the second respondent not being an issue before this court, the document tendered in this regard is irrelevant and should be expunged. Like, that is not even given. They further went on to explain a lot of things. For me, I didn't even think those explanations were very necessary. But, lawyers will be lawyers. So, but just to save time, I wouldn't want to read those explanations because I think the main point is that we are not contending. We are not the ones contending. So they already established the fact that they are mixing up proceedings. They are mistaking PDP's proceeding for LP. Very, very, they are not coordinated, simply put. Anyway, the next thing that was tendered was Nigerian passport issued in 2011, data page of Nigerian passport, visas, US visas, that document, if you remember, they tendered the document like that. So I like this particular point. He said, we urge that the court should expunge exhibit ROA 11, blah, 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 all those things which have nothing to do in answering the questions of the forfeiture of $460,000 by the second respondent to the U.S. government. Forfeiture of money in whatever guise does not confer benefits, except the second and third respondent are rendering this exhibit to show that there was compensation given to the second respondent for forfeiting $460,000 to the U.S. government. So far, neither in their pleadings nor in the testimony of their law witness did they lead evidence to that fact. To that effect, we urge the court to expunge this. My lord, we adopt the argument of paragraph 33(1). So they adopt some other argument to do this. But why I'm laughing is because what they are technically just saying, simply saying rather, is that the passport, because even here I was thinking they should even say they did not question his citizenship, but it was wise, like Yusuf Maxwell said, it was wise for them to assume this was related to forfeiture and question it on that ground, and just simply say that if you do forfeiture, it does not mean you cannot enter US again, right? They are not saying you will not get benefits. It does not confer benefits.
I argued it on this space now. I told you guys some time ago that in fact what the lawyer said in court, because that was what he said in court, it was a blatant lie. Because he asked his witness, who also affirmed it is a blatant lie that immediately you forfeit, immediately you are charged for criminal this thing, that you can never again in life be allowed into the United States of America. It is a lie. The only thing is that yes, you may not be allowed, but after a time you can be allowed, and there are waivers which can be granted to people whom after conviction, and moreover his own is just a forfeiture that is more like a fine, not like he was imprisoned or sentenced to prison and the rest. This guy, Ibori and the rest, such people, they can still grant them waivers, and then they will still enter into those countries subsequently. So it is not even an issue at all.
Yeah. You saw where they literally took a swipe at the guy. He said, look at what I said. He said, except they are saying he's rendering those exhibits to show that there was a compensation. So more like they compensated him for forfeiting the money, which was very funny. Anyway, the next objection was to admission of the being petitioner forwarding letter of membership registration to the INEC chairman dated 25th of blah blah blah, and that letter about Peter Obi's membership. Now look at what they said on exhibits ROA 17 and ROA 18. We submit that they are totally irrelevant to determine the petition for the following reason. One, they say one, that the issue of membership is already an internal affair of the party. Is an internal affair of the party. So these people now are doing busybody. Those things that court said PDP was doing. Knows something. That though the second and third respondents have raised a preliminary objection on membership of the first and second petitioner, the membership issue in regards has been put to rest by this court in APM versus INEC. What is important is that the Court of Appeal confirmed that the first petitioner is a member of the second petitioner, that Peter Obi is a member of LP. That the issue of membership does not fall under qualifying or disqualifying elements under Section 134 of the Electoral Act. So, okay, let me go on. That the essence of Section 77 of the Electoral Act was to guide against political parties' impunity and rascality towards primary election. For instance, the membership register is required to be presented to INEC so as not to shortchange the aspirants during primaries when the political parties use when the political parties use people who are not members of the party to make a return of their own choice. Membership of a political party is a continuous process that does not abate upon submission of membership register to INEC. As such, anyone can become a member of a political party after the submission of the membership register to INEC.
How many times I talk that thing for you? How many times I shout down for you?
Yusuf Maxwell, all this objection, we have objected it already. So we objected it on their behalf. Anyway, they went further to explain all that. Just to save time, I won't go into that. Then the next document was CTC of the report of Committee on the Location of Federal Capital Territory, or Federal Capital of Nigeria, location Bawu. He said, my lord, we adopt the argument in paragraph 3.8, 3.1, 3.8 and 3.110. I mean, I will not go into it. That is not a big issue. The next one is acknowledgement copy of letter of voluntary withdrawal by the third respondent. That the acknowledgement copy of the letter that Shettima used to withdraw, addressed to the national chairman of All Progressive Congress. So the letter was even addressed to APC national chairman. He said, we urge this court to respond the exhibit from his record, being a letter purported to have been personally authored by the third respondent to the fourth respondent. So letter that is just within you and your friends, literally, on the 6 days of July. This exhibit was tendered without the maker, who is to be cross-examined on the same. The document was tendered from the bar, and the maker of same was never called to give life to it. See the case of blah, blah, blah. We urge the court to hold that it is inadmissible and expunged from its record. You say, I don't know if I want to speak to it, but if not, I think that's self-explanatory. They are simply saying the letter was from Shettima to APC. Most people are responding to this case. What do you expect? It's like saying you're accusing somebody of stealing, and the person has to say, ask my father, ask my father. I don't understand. Your father is not supposed to say you didn't steal before. Like a very, very annoying argument. Anyway, objection to the admissibility of exhibit ROA being CTC of page 28 of Tribune, Nigerian Tribune newspaper. This particular objection was I loved it. He said, on this objection, he said, we urge the court to disregard the headline. We urge the court to disregard the headline, but the content which detailed precisely the true intention of INEC on election day. For the avoidance of doubt, the true reporting was that raw result, they put raw in quote, raw result will not be uploaded and transmitted, which we all know, fine, right? But what
sorry, sorry, please, where are you? Please let me follow you. Please, sorry, where are you?
Page 7.
3 points what? 3 points what?
3.20.
Okay, thank you.
Yeah. So he said, for the avoidance of doubt, the true reporting was, and remember, this is the Tribune newspaper that they wanted to tender so badly every day, tender, Tribune newspaper. INEC said they will not transmit raw figures. So they went on and said,
they were asking every witness, are you aware on social days that INEC
they wanted to
said that they were
force. He said, for the avoidance of doubt, the true reporting was raw results will not be uploaded and transmitted, but that the commission would upload and transmit real time on election day is the hard copy of what they will transmit is the hard copy of Form 68A, which contains the raw result of all the political parties. The commission, listen, the commission, in our wisdom, gave reasons for this mode of transmission, as it is not susceptible to hacking. So it means INEC cannot obviously anybody hacked them now. In other words, the photo or scanned copy of the Form 68A is what the commission would upload and transmit to the IRF. It doesn't like say you just call, use your hand, present what it will kill you. Who sent you? Anyway, the next thing that they objected was ECOWAS preliminary report. This was also very interesting. The objection was that this document is a copy of a public document for which the only form of it is to be admissible if it is in the original form or it is certified form. Exhibit RO827 is not any of these forms to render it admissible by this court. I'm laughing for a reason because I think anybody that followed this case would understand what that means. Falling short of the
so it's like wait 1 minute. So meaning that it looks like the report that they tendered, it wasn't certified by ECOWAS.
Exactly.
Neither was it issued in its original form. It's as if they just went online, printed it, and brought it to the court.
You see.
Dodo. They want to tender. They don't tender now. And they hear you every day.
I was laughing when I was reading this document yesterday because I was like, these are open lawyers. He reached for Tinubu to go find these guys because it is annoying. I have to explain that place because I know some people will say, but we tendered EU reports now. Are they also saying they should not accept EU reports? Listen, just Maxwell just explain it. The EU report that we tendered were certified true copies. And if you know what certified true copy means by law, it means it's a copy of the original. So we couldn't have gone online to download EU reports, the one we saw on Twitter, and go and tender it and expect the court to hold it in high esteem. It will be susceptible to attack of objections. So what happened here is that they went to download ECOWAS reports, did not ask ECOWAS to certify it as true copy, and came to tender it. So it was a very, I laughed when I saw it. It was very interesting. All right, the next thing that they objected to, and I think it's almost done, for what we objected to, the reply is simple. The reply to APC's objection is simple, so we'll not take more time on that. The next thing that they objected to is the American Bar Association membership card in the name of Michael Opeyemi Bamidele. So they were like, okay, this is when the end. Finally, we all the call to respond exhibit RO828, which is this particular document. For it was never in the witness statement on oath of the ROW21. ROW1, sorry, to the second and third respondent. And you know why this is very important. If you remember, every of our witness that was called, just to put it online, they will ask the witness that in your witness statement of oath, or on oath,
in paragraph so and so,
yes,
you told this honorable court that there was also documents. If you have shown this document, will you identify it? Yes.
Bam.
How will you identify it? My name, my signature is on it. Okay, he's shown the document. I will always type it there. He's shown the document.
Yes.
He affirms that is the document and it's admissible. How will you want to tender a document before the court and you don't put it in your witness statement on oath? It is not a public document that you can tender from the bar. It is not a certified public document that you can tender from the bar. And you just tender the document without it being on oath. So I not just know, sir. I not just know.
See, Yusuf Maxwell, you know, I saw a lot of errors. I was telling someone yesterday. And this is like the end of the objection. Maybe the next thing we'll touch a little is the reply. The reply is just really the same. You know, because APC's objections were the same. So the reply, if you go to the reply document to their objection, it's almost the same thing. We make reference to the argument. It's only two things I'll just read from there. But before I read it, I told somebody yesterday that Tinubu already had a bad case because what happened in this election was glaring. So Tinubu was already in a bad position, right? But as if that was not enough. I mean, it should have also been fair enough if Tinubu hired, with all due respect, since we are now respecting lawyers, with all due respect, in the word of Peter Obi, as our respected elder brothers. But it would have also been very good if Tinubu, knowing that his case was very bad, had hired a very good crop of lawyers. So that by now what we'll be saying is that, these lawyers, they are bad, they twisted, as in, we'll be saying that they are making it difficult for the case to be proven. But as if that was not bad enough, Tinubu literally hired, I don't know, let me not insult them, to be honest. I don't know how good they were before. But in this case, for some reason, they performed extremely poorly. And I said this on the 1 Million March crew group. I said this some time back that the kind of mistake that APC lawyers made in this case is disturbing. I don't understand. Then Uncle Akadi is here. He said something that stuck to my head when he said it. And paraphrased, I cannot quote what he said, but what he said that was very vital is that APC and Tinubu have gotten so used to doing things illegally. As in, so they have gotten so used to their impunity that they don't bother going to read anything. And I was asking that question based off of APF petition. I was asking myself that, how did APC make that mistake? They were not in a hurry. Masari was not in a hurry to step down. He could have waited. And I'm talking about APM's petition. If you don't know it, you may not be able to follow this particular part. They could have waited. They were not in a hurry. But because they are gotten so used to impunity, they can do anything. You know, like Peter B now. For some of us, when we engage people that want to run for governorship, we will ask them. The other day we were in space with Achona and a couple of people. But we'll come and ask them, did you check the Electoral Act for this thing before you did it? Did you confirm if it's a law or not? Peter Obi, before joining Labour Party, must have read the Electoral Act, invited lawyers, consulted, and asked them questions. But APC, they feel like, come on, to hell with everybody. We can't. No need, don't worry, don't check what is there. Don't. So now, they have found themselves, even their lawyers also made that mistake. They have found themselves breaking laws up and down, left, right, and center. It is why I say it every time that anything that makes Tinubu's presidency upheld, personally, just forget Nigeria. I don't, nobody should tell me anything, but we can cruise, we can vibe, we can watch Big Brother, watch everything, but see, forget, Nigeria is gone. Anybody should not, don't think about anything in Nigeria. I told myself this morning when I woke up, I said, if the judiciary does not do the right thing, the only thing that will concern me and Nigeria is when Nigerians really wake up to a revolution. That's the only thing that will concern me and Nigeria ever again. So, I mean, it is too obvious. It is too obvious. For the responses, like I said, it's basically just three things that they responded to. Okay, but let me pause on the response. So maybe Yusuf Maxwell can take some people, because I don't want to round up in the next 30 minutes so that I can take a couple of people that want to speak. Arigosaki, please go ahead. I know you were here for a long time. Then we'll come to Mr. Kolade and $1 million girl. Arigosaki, go ahead.
Thank you, Well-meaning. Just 3 submissions. Number 1, the question you asked about why is APC lawyers making this mistake. My simple answer there is I will refer you to go and read a very classic book written by Francis Cardinal Arenza. The title of that book is God's Invisible Hand. It's about 400-page work. God's Invisible Hand. So I think things that have happened around Peter Obi is just God's invisible hand. You know, so that invisible hand appears to becloud the sense of reasoning of other opposition against him. So I think that is what is at play there. So that's my first submission. Then the next submission I want to make is on the issue of that Bamidele. So my kind question is, suppose that based on the argument of LP, that what the Bamidele tendered as a membership card also should be disregarded, does it mean that upon disregarding it, that such witness is not credible? And does it mean that if it is not credible, all arguments inferred by LP based on what the witness deposed, you know, does it mean that those arguments will no longer be relevant since the maker is not credible? I don't know how to put it, but I believe UC should understand what I'm trying to ask.
You are already putting it correctly, or you have already put it correctly, so don't worry yourself of not knowing how to put it. So very simple. Now, for the witness, you wanted to say something.
I wanted to say,
Do you want to say something?
I wanted to say, I find it difficult to speak into. So, no.
Wait, you should maybe mute your mic.
Okay.
Yeah. So the third, before you answer, the third thing I want to say is based on the question I asked you yesterday. I also asked Well-meaning yesterday that in all this argument, I have not seen, because there was one of the objections about Peter Obi did not list the states.
Arigosaki, that's where I'm coming to. In fact, if you're able to finish fast, we'll get there. Easily reply.
All right. So you can now answer, you see.
Okay, now what this just does is that the weight that will be placed on the evidence of the witness will be reduced. This may not totally expunge the testimony of the witness, but the weight that will be placed, because since his ID card, which he claimed to tender before the court, is already questionable or cannot be admitted, he may not even be seen as a lawyer to give all the views that he gave in court. So the weight that may be attached to his witness testimony or his witness statements will drop to, a lower range. That is what it means. As for the arguments that are already held, so to whatever point that the credibility has dropped or the weight that will be attached to his witness has dropped, the evidence would still need to, what do you call it? The arguments will now still need to cover up in case the entire evidence of the witness is not taken away from, the court's record. I don't know if that answers your question.
Exactly, it answers. Thank you.
Yeah. Let's quickly go to Mr. Kolade. Let's be fast so we can go through the reply, which I think was making reference to.
Thank you so much, my brother. I just came up to give both of you, yourself and UC, your flowers. You guys are awesome. We sincerely appreciate all you guys do, and not just the two of you alone, to all the M1MMC crew. You guys are awesome. We thank you. We love you guys so much, and would always remain there for each other. For me, sincerely, I won't lie to you. You get it when you're busy, you have people analyzing things, you have people breaking down things, using their talent without being paid. It goes a long way. And this also brings me to, well, since yesterday, I don't get my own, I don't close that door. Pata, pata. Because when I read this in myself, I was just laughing. That, man, these guys they are gonna. APC is a gunner. And like somebody like Arigosaki just said, the hand of God is in all of this, because I still can't fathom what exactly the kind of silly mistakes they are making. Even me, that I'm not a lawyer, I think deeply than the way they thought. Maybe they were so much banking that what's it called, technicalities, all they're looking for, the judge, they can pay the highest amount. But thank you, Nigerians. Thank you for standing up. Truly, if we had not stood up like the way we are right now, they would have found their way. What are we talking about? Maybe this is what you know. If you don't know, what do you want to say? If there were no people in court to give us live update of what exactly is happening, how do we want to know? If you don't know, what do you want to discuss about? It's because we are discussing this thing. It's because to the layman, to somebody that does not know anything at all, now knows. Now let us come and see how this justice is. Will now come and tell us that what we all read ourselves is not them say. This is not hearsay now. This is what we saw, what was submitted. We all read it ourselves. Let us see how they want to come and tell us otherwise. It's a big fix they are in. So for these guys' lawyers, they know from day one. So I won't, but one thing I just know, even if it's UC that is called to come and defend them, there's a way you can defend your clients and just plead for mercy or plead for, you get it, but they are not coming. It's that arrogance for me. It's not that arrogance that, yeah, you can do anything, you are above everybody. And that is what we bring, not just Tinubu, the entire establishment that think they can steal from the people without any repercussion or without anybody doing anything. That is what will bring them down. And not just bringing them down, they must go to jail. They must go to jail. I hope when we get to that point, we will tell our principal, these people must go to jail. It is high time the word you will go to jail begin to make sense in Nigeria. If you are outside of Nigeria, you know it is something you don't want to hear. If you do me any little thing, I will let you know you will go to jail. And right there, you correct yourself. You sit up. But in Nigeria, they tell you you will go to jail. You won't be the one to tell them and go to court. Because because we believe we can buy our way out of any situation. But the reverse is going to become the case when our principal gets his mandate back. Thank you so much, guys.
Yeah.
Really, everything you said, I'm in support of it. That is my own stand too, from the way you analyzed it. So thank you, my people. Thank you,
Thank
guys.
you very much, Mr. Kolade. Thank you. You are totally right. See, the truth is that, bans aside, you don't like Tinubu, you don't like anybody aside. There's no legal pathway out for Tinubu's presidency to be upheld. That's a given. So that statement, like I say, it simply means that the court will have to trample literally on the constitution of Nigeria, trample on the rule of law, make Nigeria is already a lawless state as it is. But it will need to be established. Nigeria is a lawless state currently by virtue of fraudnicality. I don't call it technicalities again. But if the judiciary opposes Tinubu's presidency for any reason whatsoever, any reason, like I said, you could as well. I told my friend this morning that we will just keep on Inshallah vibes. until one day, one man somewhere in Jigawa State will be reading a newspaper as in we just be standing in front of newspaper stand, haven't eaten for 2 days, and we see on the newspaper National Assembly with the face of Akpabio saying National Assembly budget 40 billion naira for bulletproof vehicles, and his head is sparred, and it was empty. That's what we lead. It will very little. So it's why when we want the judiciary, it's not a giving this thing. Before we close this space, I think the last thing, after I've read this replies briefly, the last thing I'll read is the closing remark of Peter Obi's legal team in their written address. That was very crucial. In fact, when I read that part before I slept, I was like, at that point, I just nodded my head and said, no, it's over. Literally, it's over. All right, let's just take $1 Million Girl before I read the replies to the objections, which is what Aribusaki is making reference to.
All right, guys, can you hear me, please?
Yeah, please go ahead.
Okay,
Meanwhile,
because my
I can
network
see
is
you here.
terrible.
I can see like Abado, you are here. Please stay and listen and know so that you will know. Just be around. Listen. Go ahead, $1 Million Girl.
Good afternoon, everyone. Thanks, UC and Women in Nigeria. First of all, I'm actually looking forward to the violence space today because it's actually really going to like shed a lot more light on who obedient are, who well-meaning Nigerians are. Because allow me just say this, guys. I think now that we're seeing the aftermath of some certain set of people's choices, they don't even understand what we're talking about. They felt we're just being sentimental, we're dumb. The older generation said we were kids, we were not smart enough. Whereas their generations failed. Their generation failed. That is why we are here. That's one question we need to keep asking them, telling ourselves that the people ahead of us, above us, they did not do all these things we do. They didn't read, they didn't dissect constitution like the way UC Maxwell, Women in Nigeria, where me, Nello, a whole lot of us have been doing. And they didn't listen too. They didn't read. Like everybody that comes here every single day, spend their data, spend their time coming here to learn. Please let us know that we are the ones ready to change the face of Nigeria. Allow me just share this briefly. The likes of Padi Banjo went to jail. The likes of Ogedengbe Macaulay went to jail. A whole lot of people that fought for the independence of this country, they were fighting against white men and they went to jail. Nelson Mandela was in jail for 27 years just because he wanted to see his people free. My point is, like what meaning Nigeria is saying right now. Me, I won't even talk about this final address or anything because see, there's nothing to be talking about in that thing again. For me, personal peace, anybody because I've gone through it. It's only a dumb person that won't know that we've won this case already. And the right thing is to give PO his mandate. If they don't give PO his mandate, the consequences. Now, my younger brother was with me some days ago. I was telling her they will soon increase your school fees. Yesterday, when they increase them, the guy said, no, what did they follow Agbado? When they increase the school fees, I send them to him sharp, say, they go increase your school, they don't increase your school fee too. Now, this is my point, guys. We are the ones that will uphold this democracy. We are the ones that will fight for it. Some people actually created it. The democracy we've been having since 1999 was fraud. It's a fraud. It's time to do something about it. Now it's not through violence. It's true standing for what is right. Thank you very much, guys. Please, before I go, there will be a space hosted by JRV Prince tomorrow. Green Pasture and myself will be having one of our honorables representing us from Lagos Federal Constituency. I don't want to announce the federal constituency yet. Please join us. We would announce that later today. Please
What
follow
time is the
Green.
space, $1 Million Girl?
Well, so we are not sure yet. We're waiting to hear from our honorable to give us the time. So, but kindly, I'll announce it on Violence Space later this evening. So, guys, please,
Okay,
just
try to
send me
confirm
the
because.
answer.
All
I'll
right,
do
okay.
that. Thank
All
you
right.
very much.
Yeah, yeah. Thank you very much, $1 million. All right, quickly, let me just go through the replies to the objection. So for those people that may not understand, what I read just now was LP's objection, the document that was tendered by the respondent that LP objected to. So what I want to read now is the reply that LP had to their own objections of to the document that LP themselves tendered. So that's really just it. I'll just jump right in. I don't know if this Maxwell is following, but I'm sure is following. So, in respect to the objections of the second and third respondent, and I'm reading from this page 3 just from the beginning. I'll skip a lot of places because it points to the same thing mostly. So they objected to, some set of documents as shown in the 5th schedule. The petitioner stated that the second respondent misconstrued the case of the petitioner. The petitioners, for example, in paragraph 59 and 109 of the petition and paragraph 60 and 102 of PW12, that's Eunice Atanko, were clear, and I'm jumping someplace, were clear in challenging the return made in favor of the second and third respondent in states where they purportedly to have won, of which Ekiti was part of the state. So all the documents are objected because they're in Ekiti. LP said in their petition, they already said they will challenge states where the respondents won. Also in paragraph 79 of the petition and paragraph 74 of the PW12 witness statement on oath, the petitioners listed states that they challenged, that were challenging. Among them includes Delta, Ebonyi, and other states of the Federation. Ultimately, non-compliance with the Electoral Act was a universal one and not restricted to only the states listed. So what they were challenging is non-compliance. They weren't challenging that we won the vote. That's why I told you that the way LP crafted the petition, it's, if you understand the way they crafted it, you know why. If what they were challenging is the number of votes, that means they will have to mention states and say this state we got so number, which is not what they were outrightly challenging. They were challenging it, but indirectly through non-compliance. Accordingly, the documents tendered substantially demonstrate to this court that the issue of non-compliance by the first respondent, that's INEC, to its law, guidelines, and relevant statutes was a universal issue. It's not an issue of they did in some state, they didn't do in some states. Transmission was everywhere. It didn't transmit in every state, right? That's the point. The second and third respondent have not denied the failure of the first respondent to comply with the provision of the Electoral Act. In light of the above, all the authorities cited by the second and third respondent are not full, and we urge the court to dismiss their objection. The allegation of blood, so talking about blood document, the allegation of blood result sheet pleaded in the paragraph 60 and 61 of the petition and witness statement on oath, respectively, tendered in this court, cuts across all the states of Nigeria. So it's already in the petition that they will plead blood results, and it cuts across the state. Hence those exhibits. If the second and third respondents had a grasp of our petition, basically they just said they didn't read the petition well. They misconstrued it. If they had a grasp of our petition, they would clearly not have proceeded to object to the admissibility of the documents tendered by the petitioners. Consequently, we urge this court to dismiss their objection. Then the other one, which I think a lot of people should pay attention to, this was a concern. I think Nello had this question when we had our. Meanwhile, guys, tomorrow YouTube will be having a show on YouTube. So follow the 1 Million Man March Crew YouTube channel. We'll talk about this, and in that particular show, you see presentation of the screen where you can look at. We will tweet about it tonight. So if you follow the handle, you also get the information. So just to let us know ahead. All right. So on their documents, they argued against, IREV report of Adamawa State, stating that it did not comply with the Section 84 of the Evidence Act. The documents in question are public documents, which pass the test of certification. So these documents, I really wish people follow that show on Sunday, because now I'm in the hurry, I can't detail that particular. Please follow the one of tomorrow. that particular act was talking about documents produced by computer, but it does not apply to INEC because that it is talking about documents produced by individuals. I'll get there. Say the requirement of Section 84 is only necessary to be made only when same is tendered by the maker, in which INEC is the only body that has the duty to tender in line with the Section 84 of the Electoral Act. It is pertinent. Okay, let me jump that. There's a place I wanted to, but somewhere in this document, they made reference to that. Yeah, okay, I think I already even read it. That part of the act is only applies to the maker of the document. So if you're an IT guy and you wanted to go tender a document that was produced from software, your computer, you will have to certify the computer and order. But in this case, it's INEC and the documents are public documents. Then also, of course, on exhibit tendered, such as they listed the exhibit. This is why I said we don't need to read it much. They said we refer to the Honorable Court to paragraph 101 of the petition as pleaded, and so on. In reaction to the 9th schedule, we repeat our argument in paragraph 1. So a lot of the argument was repeated because they already said that those documents, they were using it to argue non-compliance, which is universal. So they were not using it to argue where they won and where they didn't win. And also, they even mentioned, states specifically. There's even a place, some of the points I mark, and I want to make reference to it. For the sake of time, I don't want to go into like granular detail. So many times, they made reference to say, again, we refer the court to paragraph this and that, and we repeat our earlier argument. So a lot of it was repeated argument, which was what I already read. If you remember what I read, one of the reasons they gave is that they are pleading it based on compliance, which costs across the state. And another thing is that they specifically said that containing states that the petition, Tinubu purportedly won specifically. And they will mention some states. So states that were not mentioned in the petition, Arigosaki, states that were not mentioned in the petitions were actually mentioned in the witness statement of oath of, what's it called now? Of Eunice Atanko, who was the star witness in this case. So that's pretty much their argument. Also, Exhibit 3, which are EC8Bs for Bayelsa and so many states, we state that our complaint concerning general election also goes for all these states. What the second respondents are doing, look at what they said now. What the second respondents are doing is to isolate the objection with regards to the states rather than viewing the whole purport of the petition. The lawyers were just going to talk about state, not the whole purport of the petition. A comparison of all forms, for example, Form EC8B can only make meaning when juxtaposed with Form EC8As and so on. So they are saying it doesn't even make sense. And if you go further in the petition, they said we refer the Honorable Court to paragraph. I'm sorry, I'm skipping a lot of places in case if you are following. This is page 5 now. We refer the Honorable Court to paragraph 71, 72, 73, and 101 of the petition, where documents were specifically pleaded. If you go to Peter Obi's petition, which I can quickly go to now, they specifically stated it, and I said it some time back when they were talking about corrupt practices. Let me tell you what they stated there. Just give me a minute. All right, they say at the trial, the petitioner shall rely on first respondents, electoral, and all other necessary documents used for the conduct of the election. They listed all those documents, EC8A, EC8B. So it's already there. So what APC was saying is that, they should list it per polling unit, which is totally very funny. Anyways, they already replied to that, which is what Arigosaki was saying. Also, right, the funny thing was, even that certification that they said the respondents didn't submit, they submitted it. Then even receipts, because one of the objections was that the respondent did not submit receipts. And LP went ahead to say on the 22nd of June, and this is in page 6, on the 22nd of June, 2023, all receipts for certified true copies of the documents obtained from INEC were tendered all and admitted through our PW 12. So they were all tendered. Then this one was quite interesting. The respondents alleged that the petitioner did not specifically plead the polling unit, ward, local government, and states. In addition, they alleged that the polling units of blood results for 18,088 polling units were not specifically pleaded. Look at what the lawyer said, and it was very funny. We submit that the request for specific polling unit or blood result is nothing but to ask for impossibility of polling unit results that are unreadable. If these units were identifiable, it follows that they will no longer be blood. That's the reason why you cannot pin it, is because they are blood. Somebody says something is blood, you are saying you should identify where they belong to. Then look at where it concludes, and this is where I'll stop. The last line in this statement says, it is clear that the second and third respondents are desperately looking for technicality to hang on to in order to scuttle justice. So I like the fact that they pointed it out to the court that what they are looking for is just technicalities. It's not anything short of what the fact is. So that's really like a summary of the replies. What I just read now is a 10-page document, but I had to quickly summarize it for the sake of everybody that is here. So we'll be rounding up very soon, but before then, if you're in the speaker section and you quickly want to say something, just ensure your hand is up, and I'll quickly give you. But we're rounding up very, very soon. Please, and if I call you, just have about 1 minute to say maybe whatever you want to say so that we can round up. No going into detailed story. All right, Arigosaki, please go ahead.
Sorry, I'm doubling too much into details, In the answer that we are giving about the states not specifically pleaded, is this a first instance of such petitioning process, or is there...
Arigosaki, what I'll just tell you is, this document is on UC Maxwell's Drive. Download it. I think I already told you this on the DM. Download it, read it like for yourself.
All right, no problem.
That would be quite helpful. I think that's the best.
No, let him proceed. Let him proceed with that question he was asking.
I'm actually looking at the time. We have about 9 minutes to round
up. Like, what I wanted to ask is whether there is maybe a case law, a case they cited.
Precedents. Yeah, there are a couple of cases. I didn't want to be reading cases.
Okay.
For example, when they say all receipts, they talked about the case of Tabik Investment and GT Bank. They talked about when they talked about some of all this, there were cases. I just didn't want to be mentioning cases that they made reference to. That's why I said if you read it on your own, you probably get a better hold of it. Instead of us, we can't read the entire document here. All right, Victor, please go ahead.
Okay, thank you very much, Max. I'm really excited at this opportunity. What I just have a few questions to ask, probably two. Maybe not the angle we are looking at. From all indication, you have dissected this document. I've gone through it. I'm not a lawyer, but I've gone through it from a literal perspective. And from your explanation, I got it all. I mean, I understand that we are in the right place. Now, my question is, what if this goes south, right? Not what we anticipate. Are we preparing our mind for what we should? Because, like you said something that you will give up. I mean, you will just hands off of Nigeria. But I just think since we have this platform, we should start preparing our mind. Just what if? Now, that's number one. Number two. So, what are we going to do? Do we have anything? I mean, is there anything we can do legally or, as together? Then the second question, which is where I kind of like looked at it critically. I am certain in a way, based on the filters that came through, that the rerun that was peddling on the social media was coming from the other camp. And it's obvious that the Agbados want it. I mean, they've seen that they already have a bad case. It's difficult to defend a bad case, right? So that was peddling. Just in case it goes that way,
All right.
Can we challenge it, please?
Yeah. So Victor,
And then finally,
I know the
finally,
question
please.
you're asking, and because we don't have time, I don't want you to keep.
Please, just one last question.
Okay, go ahead.
Just one last question, sir. If this is nullified, like tomorrow, will when this is with the final verdict, when this is, I believe this is going to be nullified. When it's nullified, is Tinubu still going to stay in the office to challenge the Supreme verdict? To challenge it in the Supreme Court, or he has to step aside? These are my questions. Thank you very much.
All right, quickly, let me just answer your question. If this is ruled against Tinubu, he will remain in office while the appeal is ongoing at the Supreme Court. He has 21 days to appeal. If he doesn't appeal in 21 days, it means he accepts it. Within that 21 days, he can remain in office and do the appeal. And throughout the time of the appeal, he will remain in office. And that's what the law says. For your first question as to what to do, I think you misunderstood what I said. I said personally, if Tinubu's presidency is upheld, okay, maybe I didn't say it completely. I don't think I said it completely. The only other thing I'll put my hand in Nigeria is whenever the Nigerians are ready to, in any way possible, take back their country. So if I wake up tomorrow morning, let's say whatever happens, and let's say, for example, the court, like I said, it has to be illegal. If the court opposes Tinubu's presidency, which is the only way is illegal, so given. The only way is that Nigeria is under state capture, given. I will just confirm it in my book. I'll just type it as, okay, confirmed. Somebody said something that Nigeria is under state capture everywhere, but the only one that has not been fully proven is the judiciary. If the judiciary opposes Tinubu's victory, it will be proven, and it will be now 100%. Even the international community will know that Nigeria is under state capture and we are gone. So let's forget that one. So my point is that the only thing personal, and this is personal to me, the only thing I will choke mouth in Nigeria again, I mean actively, like this, is when, if I wake up one day, I see Nigerians are ready for a revolution to take back their country, I go pull mouth. But I'm not going to come and say, oh, let's get ready, let's plan for 2027, let's do, God, it go shock you. And okay, I think I answered your two questions. All right. If you are the speaker section and your hand is not up, my assumption is that you don't want to speak. Believe me, I will not call you. And the space is about to end. Because of, violence space is starting soon. And today's violence space is very important. It's very key. So even from the music time, I want to be there. I want to hear the music. So, Mr. Martin, I specifically called you because I think I dropped you because you didn't raise your hand, but you requested immediately. So please go ahead.
I wanted to ask, what is the ultimate prayer of the LP in their address now in this reply? Is it that the petitioners are saying that the mandate should be given to them, or that they are looking for disqualification, or for the contest to be, to be a rerun or something? That's my question.
All right. So, go ahead. Okay, you had another question.
I said, what is the ultimate prayer?
Okay. I wanted to answer the question. Yeah. So, first of all, prayers are not included in written addresses. They are included in the petition, right? So, the prayers are already in the petition. And I tried explaining it yesterday. What is included in the written address are issues for determination. So, first of all, to determine whether based on this and this and this and this, Tinubu is qualified. To determine whether based on this, the INEC complied with the act substantially enough. To determine whether based on this, 25% is compulsory. To determine issue for determination. That's what is there. So that's what is in this written address. If you are talking about prayers, Peter Obi's prayer is in the petition. I wouldn't want to go into details, but simply put, Peter Obi's prayer is clear. The first prayer is really, based on valid votes, declare me the winner and disqualify Tinubu. That's the first scenario. The second prayer is disqualify Tinubu, but if you agree with us that the election was not in substantial compliance, then you can order for a fresh election, but disqualify Tinubu, and so on. You get? So you can't pray to contradicting prayers. So they can't say we won the election and at the same time heavily also say is in non-compliance. So the way they are saying it is, we say the election is not in compliance. That's our first stand. But if you are going to go past it and say it's in compliance, then regularize the vote and you see that we won. That's like the simplest layman way to put it. Martin, do you get it? Okay, I think you got it. Okay, Odigie, please quickly go ahead.
I greet my obedient family. Now, good afternoon, everybody. You see Maxwell. Good afternoon. Women in Nigeria. Good afternoon. All of now, good afternoon. Man, I'm just since there was a tweet I saw yesterday. Since that yesterday night, I have not been myself. That tweet, that the thing don't they disturb my spirit and soul. And the tweet was actually
Odigie,
from
what is the tweet?
the tweet is from our own David
David
Hydoni.
Udein.
David Hydoni.
Okay, I know what. Why you
As
say I
regard the yesterday Mitty or something like that. He said Mitty with some SSS whatever.
Odigie. So
I'm coming. You see, I just want to just chip in something. I see. I don't know. Let us praise. It's not true. Let us praise not true, because these people, if it is true, the thing will backfire on them. That I can assure them. Wherever they let them keep planning, their voice cannot suppress our voice. I just cannot reason how this thing is, how everything is going. I don't. See, the thing will backfire on them. Just, they should not try it. Oh, they should not try. This is not IPOB matter. They hope they don't know that this is not IPOB matter. We are talking of obedient issue here, and obedience is everywhere. I doubt if they know this. Obedience is everywhere. So if they think they are smart, the thing will even start from their house. So I just want to anyhow I will say it. Anybody hearing the sound of my voice, help me talk to these people. This thing will backfire on them. Any plan that they are planning to backfire on them.
All right.
Thank you.
All right. Okay. I mean, I think we all have different temperaments. So I probably saw that tweet before you, and I can guarantee you that I was so undisturbed. I did not even, and I'm not even pretending, I'm not lying. Till now, if not like when you say you saw a tweet, I was like, okay, I know what you must be talking about. I am so undisturbed. I don't know, maybe it's just me. I am not going to focus on it. I am not bothered. I don't even know how to put it. So, the truth is that we have a very strong petition. Nigeria is a country, every country has to live by the rule of law. So, we can choose in Nigeria whether we want to live by the rule of law or not. But we cannot force it if, people at the end of affair decided to want to lead to chaos. The last line of LP's introduction yesterday, and I read it. And let me just quickly scroll to it because I want to read it verbatim. Says, sorry, I really want to read it verbatim. I don't want to paraphrase it. This LP's petition, second, third, yeah, okay. It says, let the second and third respondents know that where the rule of law is trampled upon or truncated, anarchy reigns supreme. Do you know why I say I'm not bothered? I mean, what you came to say is, you are saying the obvious. Like, it is known. If they do this any other way, it's a call to anarchy, it's a call to anything that Nigerians deem fit. Everybody will approach it different way. It's why I don't really like to talk about, what are we going to do? Because if I tell you what I will do, you may not agree with it. So you will do what we will do. So people that think this is the way, there are people that the best way they will think to do it is to make sure that they attack the Nigerian government and illegitimize it. There are people that we think the best way is to make sure that they occupy the streets, close all the airports. There are people that we think that everybody's best way will be different. And I cannot be here saying, this is the best way. I will be lying. My best way will be totally different from anybody's best way. But one thing will be clear, that if the judiciary tramples upon the rule of law or they truncate it, it's an actual call to real anarchy, the real one, not the one Tinubu was saying. So it is not me, I'm not bothered. I don't know why people, I read all these things a lot of the time to just assure myself that enough was done. I don't want to feel like, oh, we could have done more. I want to assure myself that enough was done, which is, I really wish, I know a lot of people have more at stake, so I can't blame you for thinking that. But, and I'm not talking to you, Odiga, and I'm just trying to round off, sorry. So, please, I don't like to deal with things out of my control. That thing was posted yesterday. There is no way I can verify if it is true. Why will I not settle down and be thinking, be panicking, be so hanged on if it is true? I said one statistic some time back, and that statistic is backed by research. It is said that 80% of the reason, is it 80% or 70% of the reason why people worry are things that they don't know if it will happen or not. Another percentage are things that they cannot do something about. As a matter of fact, when all was said and done, it was said that the only percentage of things that we worry about are things that we have control over is less than 8%. So why will I sit down and say, oh, I heard this? Instead of me to settle down and be reading this petition and be sure that our case is correct, I will now be panicking myself. So for me, I don't know. I cannot tell anybody not to panic. But the truth is, if they want to invite whatever to Nigeria, we cannot stop them from doing it. So why will I mean, is it my talk now that will now make Tinubu to say, oh, and don't do it again, stop it. Whoever wanted to do it knows that if he does it, Nigeria will be angry. I will not be the one to tell him. So why will I now be bothering myself to say it? You know. And which is why we end on this note, on when our petition ends. Before I will give it to Yusuf Maxwell and we'll close. Where our petition ends, in the conclusion of our written address, this is the last paragraph of that written address before signatures. He said, in conclusion, and I need everybody to pay attention. In conclusion, may we respectfully commend to your lordship the words on marble of the Kenyan Supreme Court in the case of Riley Odinga and Anor independent electoral boundaries, blah, 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 in Kenya, when in nullifying the election that returned His Excellency Uhuru Kenyatta as the winner of the Kenya presidential election in 2017, said 13991, what of the argument that this court should not subvert the will of the people? This court is one of those to whom that sovereign power has been delegated under Article 130C of the same constitution. This is from Kenya. All its power, including that of invalidating a presidential election, is not self-giving or forcefully given, but is donated by the people of Kenya. Basically, all the power that the Supreme Court has today is donated by the people of Nigeria. To dishonestly exercise that delegated power and to close our eyes to constitutional violations would be a dereliction of duty, and we refuse to accept the invitation to do so, however popular that invitation might be. So basically saying, however difficult it might be for them to want to nullify the election or disqualify Tinubu, they should refuse, no matter how difficult it is. Therefore, however burdensome, let the majesty of the Constitution, listen, therefore, however burdensome, let the majesty of the Constitution reverberate across the length and breadth of our motherland. Let it bubble from our rivers and ocean. Let it boomerang from our hills and mountains. Let it senerate our household from the trees. Let it sprout from our institution of learning. Let it toll from our sanctums of prayer. And to those who bear the responsibility of leadership, let it be a constant irritant. So let it irritate Tinubu. Let Tinubu be angry with the Constitution. Let it say, oh, heaven and earth will fall. But the Constitution must be upheld. Go and read that last paragraph whenever you are free. Then you will know that there is no need to worry about whatever the court will do. I don't worry about it. Let them do what they want to do. But at the end of the day, Anybody that refuses to uphold the Constitution of Nigeria cause Nigeria to do anything that they like. And it is up to Nigerians. You see, Maxwell, I don't know if you have a closing statement. Okay, I know you see Maxwell must be busy now. So if you see Maxwell is not here, let me just quickly announce. So we're going straight to violence space from here. Please, people. Okay, you see Maxwell, go ahead.
All right. Thank you, everybody. I want to appreciate you guys for being out here with us. I want to especially thank Well-Meaning Nigeria. Come on, you deserve all the accolades and all the flowers that you can get. Doing all of this. Seriously, kudos to you. And thank you for each and every one of you, the most valuable persons on the space, our listeners who have been here with us from the beginning till this time that we are bringing it to an end. God bless you. Thank you for all the support. Thank you for your kind words, your prayers, and everything. We are deeply grateful. Keep your tabs on, keep it on check. A lot of things are going to happen in a few days to come, and we'll sure be at the front seat to bring them out here to you and to see that we retrieve back our mandate. Nothing to say too much, just good night from me to you.
All right, thank you very much, UC Maxwell. As we round up, I just want to tell everybody, I know a couple of people would have had questions. So this is not the end, and I'm glad that today we're able to trash this, because I wanted us to do this today because maybe by tomorrow or next week we'll be seeing if INEC, the ones to INEC, the ones to APC. So there are a lot of documents, and I don't want us to keep piling it up. We'll be here again on Monday. There's a chance that we might host a space tomorrow. That's why I wanted to confirm from. We might be hosting tomorrow. I'm not so sure. Please don't take my word for it. We might be hosting the Labour Party youth leader to discuss some issues relating to National Assembly. But I'll confirm from them, my organs. So if you go take my word for it, now you're on your own. But you'll find out. But tomorrow we'll be live. We'll be live on YouTube for a show from 4 p.m. to 5 p.m. Follow this handle now if you've not followed it. The 1 million man, this handle that is hosting 1MMC. Follow it now if you've not followed it, so that we can tomorrow you can follow that particular show. It's usually very, very helpful. But I can't round up without my auntie Anka Dede, a very respected auntie of mine. Auntie Anka Dede.
Thank you so much. Well-meaning. I kept praying. I said, I know you're concluding. I know we are pushing the time. I know we have to go over to violence space. But my brother, after listening to your conclusion, I could not resist asking for the mic. I know that's why you bear our name, Well-meaning Nigerian, all of us. Please forgive me if I don't go passing out greetings. I stand on all the protocols from here to violence space. But I just want to thank Well-meaning Nigerian, and of course, UC Maxwell and all our speakers and listeners. But this is last conclusion. I want to say it was like a home run. He hit it through to the audience. Pick it, grab it, hold on to it. That conclusion does it for me. Right now, I no longer even feel like reading. I printed out. I don't even feel like reading because the conclusion does it for me. Please rest assured. Victory must be ours. Justice must prevail. We have a constitution. If we have to remain a country, we have to follow our constitution. Thank you so much for making that loud and clear to all our audience listeners. And I truly, truly appreciate what the Obedient Movement have been doing, what you all have been doing, representing, reading, explaining, running spaces from here and there. I listen, I love listening, but I just couldn't resist coming up to say thank you, because what Well-meaning just read out is supposed to bring a lot of comfort to people who have been asking, wondering, did they say this? Did they say that? What is this propaganda? What is this breaking news? Let us rest and be assured that justice shall prevail. Thank you all so much, and have a wonderful weekend. Thank you. I yield my mic.
All right, thank you very much, Auntie Anka Dede. So please, guys, I'm still here because I want to follow the handle tomorrow, so that by the time we announce the show on YouTube, you get it. We'll be here maybe if not tomorrow for the space with the LP National Youth Leader. we'll be here on Monday for our normal spaces, where we'll be back to ground mobilization, strong one this time. So please try to always be around. During that whole part, we'll be also talking about this. You can ask question. Right about now, we'll be heading to Violence Space. Please don't come and pity me on Violence Space. Some people will come and say, when we live in Nigeria, you've not this. Don't worry. When we live in Nigeria, it's doing fine. All right, thank you everybody for coming. Thank you. We appreciate your coming. And always, we do this really, really for God and for country.